Good evening. I'd like to call the meeting to order. Welcome to the Marlboro Township Board of Education Board Meeting, May 2nd, 2023, 7 p.m. Finn, roll call, please.
Sure. Good evening, everybody. Mrs. Jankowski?
Here.
Mr. Lewansky?
Here.
Mrs. Mendez?
Here.
Mr. Petruno?
Here.
Mrs. Piernick?
Here.
Mrs. Rosado?
Here.
Mrs. Shrem? Mrs. Seward?
Here.
And Mrs. Amster?
Here. Sunshine Law. Be advised that this meeting is being held in accordance with the Open Public Meetings Act, Chapter 231 PL 1975 Sunshine Law, and that adequate notice of the date, time, and agenda has been sent to the Asbury Park Press and has been posted and filed with the Marlboro Township Clerk. Copies have also been sent to each district school and other area newspapers in accordance with the law. I won't read in full, but I will draw your attention to the statement of videotaping of public portion of Board of Education meetings, public comment statement, and no smoking on school grounds. Can we please stand for the Pledge of Allegiance? Announcements, Mr. Ballone.
No announcements.
Okay. Then, public comments, please.
I do not have my lists in front of me, but does anybody like to speak? Mr. Amster.
I apologize to everybody.
So I'd just like to thank everyone for last week. I know it was a long and difficult meeting. I'd like to thank you for your votes and considering not only the students of this town, but also the citizens. I don't know if you're aware, I'm assuming maybe you are, but unfortunately the Freehold Regional School System also had a budget meeting last week and a vote, and they did go to 4%, so that will affect our taxes as well. So I appreciate the hard work to try to mitigate some of that. So it won't just be the 2.7% tax increase. I would imagine it's going to be 6.7%. So again, I just want to say thank you for that and all your hard work. Thank you.
Thank you.
Thank you.
Good evening, Deborah Van Edom, Morganville, New Jersey. Just like Seth, I guess great minds think alike. I really appreciate all your hard work and dedication to making the cuts that you had to make. You are being proactive versus reactive. And what I'm seeing in Freehold with the busing is that they really should have started looking at cuts years ago. So thank you very much. I know it was not easy. It was hard decisions to make. Thank you.
See no more.
Mr. Ballone, communications?
No communications.
HIB?
Harassment, intimidation, bullying report, April 20th, 2023 through April 26th, 2023. One incident.
Approval of minutes resolution. Christina, would you like to read that one?
Sure. Approval of minutes. Be it resolved that the minutes of the following meetings be approved as submitted. Meeting date, March 14th, 2023, special and executive. I so move.
Do I have a second? Any discussion?
I just wanted to say that as far as the approval of minutes, I'm going to be abstaining until we get to meetings that I was a part of the board. So I just wanted to put that out there.
Any discussion? Ben, roll call, please.
Sure. Mrs. Seward?
Yes.
Mrs. Jankowski?
Abstain.
Thank you. Mr. Lewansky?
Yes.
Mrs. Mendez?
Yes.
Mr. Petruno?
Yes.
Mrs. Piernick?
Yes.
Mrs. Rosado?
Yes.
And Mrs. Amster?
Yes. Organization matters. Jessica, can you please read?
The superintendent of schools submits the following resolutions for approval. 1, board secretary. 2, board attorney. 3, insurance consultant. 4, school physician. 5, board designee. 6, public agency compliance officer. 7, District Section 504 Coordinator. 8, Section 504 Coordinator for Program Accessibility. 9, Approval of Qualified Purchasing Agent for Bidding, Purchasing, and Sale of Property. 10, Procurement of Goods and Services through State Agency for the 2023-2024 school year. 11, Purchase Professional Services. 12, Open Public Records Act. 13, Designation of Legal Newspapers. 14, Tax Sheltered Annuity Companies. I so move.
Do I have a second? Michael? Any discussion? I see none. Vin?
Sure. Mrs. Mendez?
Yes.
Mr. Petruno?
Yes.
Mrs. Rosado?
Yes to everything, but I abstain from number 3. And Brown and Brown Benefit Advisor from number 11 only. And just to go on record, going forward, if I miss anything on the agenda, in the future, I will always be abstaining from anything regarding Brown and Brown. Thank you.
Thank you. Mrs. Seward?
Yes.
Mrs. Jankowski?
Yes.
Mr. Lalansky?
Yes.
Mrs. Piernick?
Yes.
And Mrs. Amster?
Yes. Financial and business operation matters. Kerry, would you like to read?
The superintendent of schools submits the following resolutions for approval. Number 1, authorize signatures. Do I have to read each one?
No,
Okay.
2, 3, yeah.
Number 2, uniform minimum charts of accountants. Number 3, after-school sports enrichment programs. Number 4, renewal of contract educational data services for purchasing procedures for the 24-25 school year. Number 5, harassment, intimidation, and bullying HIB report. Number 6, approval of agreement, E-Rate Consulting, Inc. Number 7, reaffirmation of team teaching integrated preschool tuition. Number 8, reaffirmation of disability insurance. Number 9, approval of addendum to extend the professional service agreement between the MT BOE and ESS Northeast LLC. Number 10, home instruction. I so move.
Do I have a second?
Who was the second?
Annette.
Okay, thank you.
Any discussion on this? I see none. Vin?
Sure. Mr. Lalansky?
Yes.
Mrs. Mendez?
Yes.
Mr. Petruno?
Yes.
Mrs. Piernick?
Yes.
Mrs. Rosado?
Yes.
Mrs. Seward?
Yes.
Mrs. Jankowski?
Yes.
And Mrs. Amster?
Yes. Curriculum matters. Annette, can you please read?
It was coming. The superintendent of schools submits the following resolution for approval. 1, curriculum guides. I so move.
Do I have a second? Christina? Any discussion? Oh, Christina.
I just had a quick question I need clarified. So if we, let's say, vote yes for the curriculum guides, and going forward, we know New Jersey learning standards are currently in the process of being revised, and they change, will we re-vote for the new curriculum if we implement new guides?
Yes, we will. So we know the math and ELA standards are coming down the pike as we speak, and the curriculum committee is working on that right now. As those get changed, we will present them to the board for approval. They'll go on the draft section of our website, which we instituted, I believe it was last year, so the community can review them before they actually get approved by the board.
Thank you, Michael.
You're welcome.
Aldo?
Yeah, actually, just on the curriculum guides, how does it, it's probably a question for Mr. Ballone, just for my own knowledge. How does it work, like, as far as reviewing them, the deep dive, is that something that we do, like, every summer, or is that just when the guides are revised, like, something new comes?
So we don't, the list that you have before you here, we don't review all of these every summer. So anytime we would review curriculum guides for 2 reasons. 1, the state comes down and they have new standards that need to be implemented by a certain date. So those would be worked on over the summer. Or if there, a lot of times we'll go over some resources. If you look at on the right side here, it says board approval date. So if typically we like to review curriculum guides within a 5-year period. So you see the 2018 guides on there. Those are the ones that we review anyway, even if the standards aren't changing. But we do know that math and ELA standards are changing.
Okay. All right, thank you. And
Welcome.
actually, that's it. Thank you.
Any other discussion on this? Vin, roll call, please.
Mrs. Jankowski,
Yes.
Mr. Lalansky,
Yes.
Mrs. Mendez,
Yes.
Mr. Paterno,
Yes.
Mrs. Piernick,
Yes.
Mrs. Rosato,
Yes.
Mrs. Seward,
Yes.
and Mrs. Amster.
Yes. Personnel matters. Michael, can you please read?
As personnel matters, superintendent of schools submits the following resolutions for approval. 1, abolish positions. 2, retirement. 3, resignations. 4, full-time teaching staff. 5, part-time teaching staff. 6, school psychologists 2023-2024 school year. 7, certified administrators 2023-2024 school year. 8, operational administrators. 9, stipend supervisor of building and grounds 2023-2024 school year. 10, non-aligned certificated administrators. 11, non-aligned non-certificated administrators. 12, non-aligned support staff 2023-2024 school year. 13, secretarial personnel 2023-2024 school year. 14, special educational instructional assistants 2023-2024 school year. 15, kindergarten basic skills instructional assistants 2023-2024 school year. 16, school monitors 2023-2024 school year. 17, school aides 2023-2024 school year. 18, building and ground staff 2023-2024 school year. 19, stipends maintenance workers. 20, head custodians, maintenance foreman, and night custodial supervisor, 2023-2024 school year. 21, stipend head custodians, maintenance foreman, and night custodial supervisor, 2023-2024 school year. 22, courier, 2023-2024 school year. 23, bus drivers, hours and salaries, 2023-2024 school year. 24, bus attendants, hours and salaries, 2023-2024 school year. 25, computer technicians, 2023-2024 school year. 26, computer technicians 2, 2023-2024 school year. 27, district network technician, 2023-2024 school year. 28, registered nurses, 2023-2024 school year. 29, permanent floater school nurse, 2023-2024 school year. 30, unpaid leave of absence. I so move.
Thank you, Michael. That was a long one. Do I have a second? Val. Any discussion? Carrie.
I think this is a question for Mr. Zittimer. I just want to confirm that I am allowed to make a vote on this because whatever the negotiations were, they're over and done with, and I can just vote on what's here, correct?
Yes, if you feel you have enough information to be able to cast a vote, you may certainly do so. If you feel that you don't have enough information, you can certainly abstain. So again, you're allowed to. The only question is, do you think you have enough to cast the vote? If you do, absolutely, it's fine.
I just wanted to make sure that any conflict with, being a part of NJEA, that because all the negotiations were done, correct?
Yeah, so
Okay.
you're a member of the NJE in another district, correct?
Correct.
Once there's a memorandum of agreement with salary guides, it's fully okay for you to participate.
Just confirming that.
Yep.
Thank you.
Any other discussion? I see none. Roll call.
Sure. Mr. Paterno,
Yes.
Mrs. Piernick,
Yes to everything except abolishing the supervisor of special services 10-month position.
thank you. Mrs. Rosato,
Yes.
Mrs. Seward,
Yes.
Mrs. Jankowski,
Yes.
Mrs. Mendez,
Yes.
Mr. Lalansky,
Yes.
and Mrs. Amster.
Yes. Mr. Balone?
Thank you. I have retirement comments for Michael Blaskovich. Mr. Blaskovich was hired as a school bus driver in September of 2015. During his 7 years of service to the district, he's done an excellent job. Throughout his years of service, Mr. Blaskovich has been conscientious and aware of the great responsibilities of his job. He proved to be proficient and thorough in the performance of his duties year after year. His commitment to the safety and well-being of the children in the district has made him an asset to the transportation department. Mike will be missed for his upbeat attitude, personality, and adaptability. He's earned the respect of the parents, children, and his peers throughout his years of service. We thank Mr. Blaskovich for his dedication, reliability, and loyalty over the years. We hope that his retirement years are happy, healthy, and fulfilling. He will be missed by everyone in the transportation department. Thank you.
Mr. Zittimer, your turn.
Good evening, everybody. Just take one of these and pass it down, please. Thank you. Good evening, members of the board, members of the community, administration. We're going to talk this evening about the New Jersey School Ethics Act. In New Jersey, there's a statute, the School Ethics Act, that governs the ethical requirements for school officials, and we'll talk about who is defined as a school official. Just need my remote here. So in the preamble to the School Ethics Act, it kind of gives a nice explanation as to why we have this law in the first place. And what it says is that in our representative form of government, it's essential that the conduct of members of local boards of education and local school administrators hold the respect and the confidence of the people. Officials must avoid conduct which is in violation of the public trust or which creates a justifiable impression among the public that such trust is being violated. The public, the community, the folks that elected, you have to have confidence that you're acting in the best interest of the school district, not for your own personal best interest, not for your financial best interests. And I always tell school officials that not only do you have to avoid actual conflicts of interest, but you also have to avoid what's called the appearance of impropriety. If something doesn't pass the smell test, if somebody's going to perhaps question whether you're voting for the best interest of the school district or for some other reason, if you're not sure, I always say to board members, take a step back, abstain. If it's a discussion in closed session, recuse yourself. I always like to err on the side of caution. I think that's the best course of action. So New Jersey law requires that we annually discuss the School Ethics Act at a meeting. It's part of the CUSAC governance standards, so we'll check that box, and it's an important discussion to have, obviously. Who does the School Ethics Act apply to? It applies to school board members, of course. It also applies to officials from the New Jersey School Boards Association, and it also applies to school administrators, the superintendent, BA, and other high-level administrators. Now, the Code of Ethics, which I handed out to everybody, only applies to school board members. So you've got the prohibited acts, the conflicts, that deals with everybody, but the Code of Ethics only applies to board members. And so the School Ethics Act essentially is broken down into two parts. We have the prohibited acts, those are the conflict of interest sections that I just handed out, and on the other side of it you'll see the Code of Ethics. That's the part that pertains solely to board members. So all of the ethics provisions are important, but let me go over them briefly with you. Section A says you're supposed to uphold and enforce all laws, rules, and regulations of the State Board of Education and court orders pertaining to the schools. Section B says you're supposed to make educational decisions in terms of the welfare of all children, regardless of race, creed, religion, national origin, and so forth. You're here for everybody. Section C says you're supposed to confine your board action to policy making, planning, and appraisal, and you're supposed to help frame those policies and plans after consulting with those who will be affected by them. As you know, in Marlboro, we have committees. That's where we do a lot of our work. The main function of a Board of Education member is to set policy for the district. You set the guidelines for the district, and you appraise. You take a step back and say, how are we doing? And then you plan for the future of the district. That is the role of a board member, distilled down to its essence in Section C. Section D says you're to carry out your responsibility not to administer the schools. We have a wonderful administration here in Marlboro. That is their job in terms of the day-to-day operations of the school district. You're not to run the district as a school board member, but you're to see that it is well run. The Code of Ethics also, not the Code of Ethics, I should say, the regulations explain what would somebody have to show to prove a violation of these various provisions that I'm talking about. And so I often get questioned, what does it mean for a board member to administer the schools? So I'm going to quote the regulation. What it says is that somebody to prove that somebody administered the schools would have to show that a board member gave a direct order to school personnel or became directly involved in activities or functions that are the responsibility of school personnel or the day-to-day administration of the school district. And I always think this is a really good example of a board member kind of getting into the weeds of administration. It's a matter out of the Delsey Board of Education, where the School Ethics Commission found that a board member violated the act when he went directly to the guidance secretary, started asking for copies of SAT reports, then began to do an inspection of the locker rooms, and then told the PE teachers how they better needed to supervise the students. That's clearly administration. Board members should not be doing inspections of schools and asking for reports directly from the staff. If you need something, if you want something, you're always supposed to go through the chief school administrator, Mr. Balone in this case. Section E says you're recognizing your authority rests with the board. You have the authority to act as board members when you're sitting at the dais through your various committees, but once you leave this room and go home, you don't have the authority, obviously, to bind the Board of Education, and you're not supposed to make personal promises or take private action outside your duties that could compromise the Board of Education. Section F, you're supposed to refuse to surrender your independent judgment to special interest or partisan political groups or use the schools for personal gain or the gains of friends. I think that's pretty self-explanatory. One thing I want to mention, though, is this doesn't mean you can't advocate for certain groups of students. If you're a parent, a special ed parent, you can absolutely advocate for special ed students as one example. So they're talking about literally surrendering your independent judgment so that you're completely losing all objectivity. That's what this is referring to. Again, it doesn't mean that you can't advocate for one group or another within the school district. Confidentiality is a huge part of being a board member. As you all know, you come across a lot of confidential information, a lot of staff information, a lot of pupil information. We are allowed by law to discuss in closed session a lot of topics that fall within the confidentiality world, and I always tell my school board clients that if the board members as a whole feel that that confidentiality is being compromised, it really undermines our ability to be an effective body, because nobody's going to want to have a conversation about anything for fear that that discussion is going to leak out into the public. So I implore boards to really strictly adhere to all of the ethics code provisions, and in particular the confidentiality piece. That section also goes on to say that you have to provide accurate information. You can certainly speak at these meetings, but it's important that you say things that are accurate. So, for instance, you couldn't say something like, I'm voting against the budget this year because we're adding 20 new administrative positions, if that was not a true statement. That would be an ethical violation. You could say, I'm voting against the budget if we're, hiring X number of positions, if that was true. And so that's the difference. Section H says you're supposed to appoint the best qualified personnel available after considering the recommendation of the superintendent. By law, the superintendent has the only authority, let me try that again. The superintendent is the one who makes all personnel recommendations to the school district. The board cannot vote to appoint somebody in a school district without the superintendent's recommendation by law. And so we are supposed to support those recommendations, and the statute goes on to say you shouldn't withhold your approval of the superintendent's personnel recommendations for arbitrary and capricious reasons. Does that mean we have to be a rubber stamp to everything the administration does? No, of course not. You should ask good questions. You should inform yourself. You should educate yourself. But at the end of the day, with respect to personnel in particular, the statute really contemplates supporting those personnel recommendations. Section I will support and protect school personnel in the proper performance of their duties. This means we're not supposed to publicly evaluate our staff. If somebody was going to show a violation of this section, what they have to show is that a board member took deliberate action which resulted in undermining, opposing, compromising, or harming school personnel in the proper performance of their duties. Section J says we're supposed to refer all complaints to the chief school administrator and act on those complaints at a public meeting only after the failure of an administrative solution. And I always say this is actually a very good provision, in my opinion, for board members. This gives board members, when they're at the local supermarket and a parent comes up to you and complains that their child's teacher is giving too much homework or whatever the case may be, to say thank you very much, I appreciate it. As you know, I'm a board member. I'm going to refer this complaint to Mr. Ballone, and I'm sure he'll get back to you in 24 hours. Or you're also allowed to refer community members to the chain of command. Have you spoken to your child's teacher? Have you spoken to the principal? What you're not supposed to do as a board member is act on that complaint and handle that complaint on your own. Next, who can file a complaint if somebody believes there's been an ethical violation? The answer is anybody. Anybody can file a complaint. The Board of Education as an entity can't file a complaint, but individuals can. There is a 6-month statute of limitations for filing those complaints. That means the complaint has to be filed within 6 months of the event, the alleged event giving rise to the complaint. The School Ethics Commission, as you know, is the only entity that could determine whether a board member in fact violated the Ethics Act or the Code of Ethics. And if there's ever a question about whether you should or shouldn't do something, you could certainly consult with me as board counsel. I'm familiar with all the decisions. But you can also request an advisory opinion from the School Ethics Commission. You could write to them and say, look, here's the question on the table. Can you tell us how we should proceed? Just to digress for a second, I had a situation in one of my districts where a high school senior got elected to the Board of Education. Literally, he was 18, he got on the Board of Education. And the question that was asked of me as the board attorney is, what are his ethical limitations? Can he vote on his teachers? Can he vote on student discipline matters? And I scratched my head because I thought I pretty much knew all this stuff. And I said, you know something? I think we need to go to the School Ethics Commission and get an advisory opinion because it was such a unique situation. And they wrote us back and told us what he could and couldn't do. So that's something that we have in our toolbox if we need it. What are the sanctions for violating the School Ethics Act? At the lightest end of the spectrum, you have a reprimand. That's a letter from the School Ethics Commission to the board member saying, you know, shame on you, you shouldn't have done that, you need to, act accordingly in the future in following the ethics. A censure is a resolution read publicly at a board meeting that we would have to read. A suspension, obviously, is removal from the board for a certain period of time, or removal in the most extreme cases. Doesn't happen very often at all, actually. Can you file an ethics complaint against somebody who's no longer on the board? What do you think? Yeah, as long as it's within that 6-month period of time, obviously suspension and removal is not going to be an option. Indemnification is something I want to highlight also. So this is a separate law, but there's a law in New Jersey that says if a complaint is brought against a board member for something arising out of and in the course of their duties as a board member, the board has to indemnify them, make them whole, cover their legal defense costs and so forth. The board has insurance for these sorts of things. And this is important. So generally, if ethics complaints are filed against board members, the Board of Education will supply counsel, an attorney, to represent the board and defend that board member at no cost to the board member. And this is an important statute, and the legislature was wise, in my opinion, because they figured who would ever run for a volunteer position if you could be subject to lawsuits, complaints, and so forth, if you were going to be out of pocket for these things. And that's the whole purpose of indemnification. There's also an separate employee indemnification statute as well. Board member free speech issues. You don't lose your First Amendment right to speak as a board member. You absolutely have the right to speak and voice your opinions on issues. That's important. But what you can't do is you can't disclose inaccurate information. We talked about that. You can't disclose confidential information or information which has the potential to compromise the board. We also are not allowed to publicly evaluate the staff. So other than that, you have a lot of latitude in terms of what you can say as a member of the board. We also have a policy that says that when you write to the local newspapers, when you give speeches to organizations, when you speak publicly, it's important that if you post on social media, I know a lot of board members like to post on social media, it's important you have a disclaimer on there saying that I'm speaking as an individual, I'm not speaking on behalf of the Board of Education, unless, of course, you've been authorized to speak on the Board of Education. And so the disclaimer, and I'm happy to send this to anybody who wants it, but that's the model language that the School Ethics Commission recommends that these statements are made in my capacity as a private citizen and not in my capacity as a board member. These statements are also not representative of the board or its individual members and solely represent my own personal opinion. So again, if you like to post on social media, Twitter, writing letters to newspapers, you can do so, but just make it clear that you're speaking as a private citizen and not on behalf of the board. Generally speaking, the board president does have the authority to speak for the Board of Education, though. All right, I'm not going to call on anybody in particular. I'm going to just throw these cases out there for your opinion. So these are actual cases that have come down, current cases from the School Ethics Commission. And by the way, if you go to the New Jersey Department of Education website, you can find all of these decisions. Basically, what I'm trying to do is boil down. Sometimes these cases are 20 pages long. I'm trying to boil them down into one slide. And it's probably not fair to you because I'm not giving you all of the facts, but just an overview of what it was. So here are the facts of this case, and this is a true or false question. Hang on one second. I just want to grab my code provisions here. Do you have an extra copy of that code? Yeah, exactly. Thank you. There's one in your agenda if you need it. Thank you. Okay. So what do you think? Section E is the section of the code that says you will recognize your authority rests with the board and make no personal promises or take private action that could compromise the board. So a board member violated E, true or false, when during an executive heated discussion ensued among the board members, and at some point one board member says to another board member, the person who filed the complaint, do you want to get punched tonight? When the complainant asked the fellow board member if she was threatening her, the respondent replied again, do you want to get punched tonight? And so the question is, did that violate Section E, recognizing your authority rests with the board and not making personal promises or taking private action that could compromise the board? What do you think? Was this a violation or not? Who thinks it was a violation? Who thinks it was not a violation? Certainly inappropriate, but who thinks it was not a violation? You're correct, it was not a violation. And I'm going to read you some quotes from the cases just so you don't think I'm making this stuff up. Here's what the School Ethics Commission said. Although the Commission certainly does not condone the comment made by respondent in executive session and agrees it was entirely inappropriate, respondent did not approach complainant in an aggressive manner, did not scream at her, did not have physical contact with her such that restraint by another board member was necessary, and did not utter her comment in public session or to a member of the public. Instead, I guess it's okay to do it between board members, you just can't do it to other folks, I guess is what they're saying, I don't know. And instead, he made the comment when discussing the superintendent's evaluation. And then it goes on to say, of note, and based upon the facts pled, the other members of the board, other than the complainant, did not appear fazed to any extent by what respondent uttered. As such, respondent's comment is best resolved as an internal governance issue and adjudicated as deemed appropriate by law enforcement as a criminal matter. However, based on the facts and circumstances here, it is not an ethics violation. So, again, highly inappropriate, should be dealt with as an internal governance matter, but not a violation of Section E. So, false, it was not a violation. How about this one? A board member violated Section B and E, and so B is making decisions in terms of the educational welfare of all children, and Section E is, again, recognizing your authority rests with the board and not taking personal promises or private action. So a board member violated Section B and E of the code when at a board meeting he asked the public to be mindful of proper decorum following a resident's use of profanity during public comment. The board member also posted on Facebook, speaking as a private citizen, it felt like we were transported back to Appalachia last night and a local dive bar closed early. So the patrons came to the board meeting. Everyone should have to wash their hair and jeans before coming up and screaming, dropping the F-bomb. It was unsightly and nauseating. Is that a violation or not a violation? What do you think? Not a violation? Anybody think it was a violation? Again, some pretty unruly board meetings, as you can see. The answer, it was not a violation. And what the Ethics Commission said here was, bear with me. It says nothing. It says neither the comments at the meeting nor his post on social media, assuming it was made in his capacity as a board member and not as a private citizen, constitutes a decision contrary to the educational welfare of children or deliberate action relating to the school district or a personal promise beyond the scope of his duties. And then it goes on to say that even if the substance of respondents' appeal to the public and his post on social media was crass, insensitive, and boorish, bless you, the respondent clearly could have used more appropriate and respectful language to reclaim order at a board meeting. A violation cannot be substantiated without the necessary factual evidence. So,
Mark,
again,
I had a quick question.
Yeah, sure.
Do you need the full disclaimer? Like he wrote, speaking as a private citizen, would that be suffice as a disclaimer, or would he need the full?
The Ethics Commission is a little bit all over the place on the disclaimer language. You know, I had a case in one of my districts where a board member wrote to the paper endorsing some candidates, and he started off by saying, I'm writing as a private citizen, and then went on to just say lots and lots of things, and they held that that was an inadequate disclaimer. I'm surprised they didn't really pounce on this disclaimer here, to be honest with you, because they're really pretty strict about having that language. How about this one? A board member violated E of the code when he replied directly to a parent from his official board member email account about the information the parent had sent to the board member. Specifically, the parent complained about a teacher's social media posting showing she was in Cancun, Mexico. The same teacher had previously spoken at board meetings about how staff returning to in-person instruction was unsafe. So meanwhile, she's in Cancun. The board member replied to the parent and stated he was appalled by the teacher's behavior, and the parent could expect a proportionate response from the district's administration. Do you think that's a violation for the board member? Yeah, clearly. That's administering the schools. That's acting on a complaint prior to the failure of an administrative solution. How about this one? A board member violated Section C. So Section C is the prohibited acts. Those are the conflicts of interest. That's where board members shouldn't act in a matter where they have a direct or indirect personal or financial matter, involvement, I should say. So did a board member violated C when he entered into exec session to discuss an Oprah lawsuit against the board, which specifically involved that particular board member's email information? Should he have recused himself from that discussion? I hear a yes. Does anybody think no? You are correct. It was a violation. He should not have. The lawsuit directly involved him. Remember I talked before about avoiding the appearance of impropriety. If something's questionable, stay out. They said that this board member clearly should have stayed out of that discussion. And what they said was, it says that the judge properly concluded that respondent should have recused himself from the executive sessions on May 7th and May 18th, 2020, because respondent had, at a minimum, a direct personal involvement in the outcome of the litigation. The judge further noted that the Oprah lawsuit involved respondent's emails and devices, and therefore the judge further concludes that a member of the public could justifiably believe that his objectivity was impaired when discussing the litigation, a resolution of the lawsuit, or the board's next steps concerning the case. Again, it directly involved him. He should have recused himself from that discussion. A few more. How about this one? Number 5. A board member who's employed in another district as a bus driver is precluded from being involved in all aspects of contract negotiations with the Bus Drivers Association in the district where he's a board member, even though the board member doesn't pay dues and is not an official member of the NJA. So you don't actually have to pay dues if you don't want to be part of the union. And so the question is, here's a board member who's a bus driver in another district. Could he participate in the negotiations in his own district where he was a board member? What do you think? Should he have recused himself or should he participate? He should recuse. It was a violation. And what they said is, even though you don't pay dues to the NJA, the fact remains the NJA is negotiating all the terms and conditions of your employment. So whether you're in it or not, that contract still governs you, and he should have recused himself. So here's a complaint where somebody pretty much just named every single provision of the Code of Ethics as having been violated. So a board member violated all of that when she advised the superintendent that she should remove the renewal of a non-tenured staff member from the agenda because the superintendent's recommendation would not be supported by the majority of the board. So basically, the board member was giving the superintendent a heads up and basically saying, look, you may want to take that off the agenda. It doesn't have everybody's support, and quite frankly, I don't think it's going to be passed. It may be embarrassing for the staff member, and that's what happened. Do you think that was a violation or not? Not a violation, correct. So what they said was, okay. It says, despite complainant's suggestion, there's nothing which requires Board of Education members who are independent voting members to blindly adopt the recommendation of the superintendent if, in their own estimation, they don't agree with it. In this way, not agreeing with the superintendent's recommendation is not in and of itself a violation of the Act. Similarly, advising the superintendent before a public board meeting that one of his recommended personnel actions would not be supported by or receive affirmative votes from the necessary number of board members is also not a violation of the Act. I thought that was an interesting case. How about number 7? A board member violated Section B and F of the code, and Section B is making decisions in terms of the educational welfare of all children and maintain schools that meet the needs of all children regardless of race, ability, creed, sex, social standing, and so forth. And Section F is refusing to surrender your independent judgment to special interest groups. So this was during the height of COVID, and a board member wore an LGBT mask. I guess it had some logo on the mask. And so was it a violation when she wore this pride mask on the board panel at the dais, clearly demonstrating her support for the LGBT community? At the meeting, there were over 300 people in attendance, predominantly representing that community. Do you think it was a violation for the board member to wear that pride mask? True or false? False. There was no violation. As a matter of fact, the School Ethics Commission actually found this complaint to be frivolous. So there is a mechanism where somebody who is on the receiving end of an ethics complaint can also ask that the School Ethics Commission declare that it's frivolous. And they rarely do that, by the way, but in this particular case, they did find that it was frivolous. How about this one? It is a violation of the Act for a board member to also serve as an executive officer of the PTA or any other PTA executive officer position. What do you think? Violation or not a violation? False. There you go. We got some people in the community who got the right answer. The answer is false. And there's a lot of ethics commission cases about volunteering in other capacities. Board members like to volunteer. Hats off to all of you. You're volunteers. And so the question is, if I'm a volunteer board member, does that mean I can't volunteer doing anything else? And the answer is no. You can volunteer and do lots of wonderful things. The limitation on that, though, is that if you are involved in a volunteer position where you're giving direct orders to staff, have significant involvement with staff, that's where the Ethics Commission finds that it may be problematic. So let me just read from this actual decision. And what the School Ethics Commission said was the advisory opinions on this issue turn on the degree of involvement a board member had with staff and students, as well as the degree to which the board member had the authority to give and receive directions and orders to staff during the involved volunteer activity. In these previously issued opinions, the Commission advised that where a board member was in a supervisory position and generally oversaw staff or students, such interaction would be inconsistent with the Act. That makes sense, right? I mean, because you're always seen as a board member, so if you're giving orders, supervising staff, that would be a no-no. But going in and reading a book to class, being a PTA officer, being a PTA member, being a member of CPAG is not going to be an issue. Okay, how about the final slide? Number 9, a board president violated Section C of the code when at a board meeting she accused the complainant of standing outside a board meeting while threatening people. The complainant further alleged the president's comments were untrue, humiliating, and caused concern with his employer. Do you think that was a violation? The final, no? I hear some no's. Anybody think it was problematic? No. And this one really kind of, the answer was it was not a violation. And this case really supported the authority of the board president here to run meetings, basically, and to exercise some control. And so what the School Ethics Commission said in this case was that, so what it said was, after a review of the facts, the commission determines that even if the facts are true, they would not support a finding that the board president violated C, because her duties as board president require her to preside over board meetings, which at times requires the board president to limit or quell highly emotional comments from the public on matters that are highly controversial. The commission acknowledges that the current political climate at the national and local level is highly charged. Consequently, public discourse can often be debased by highly partisan and highly personal attacks. This is also true at the school board level. The commission encourages board members, school officials, parents, and community members to recommit to civility while debating the myriad of public policy matters implicating the delivery of education and educational services to New Jersey's public school students. Nonetheless, in this matter, the commission determines that respondents' actions did not go beyond policy-making duties as a board member. Therefore, commission concludes that there was no violation of Section C and the case should be dismissed. Any questions on anything I talked about today?
Mark, I have two questions.
Sure.
Regarding the disclaimer and
Yes.
regarding involvement in school PTAs
Yep.
and PTOs. The first one is the disclaimer, and so I hear you on the fact of where I've read, you know, I'm a private citizen, may not absolve you, right, of your statement. But if anybody were to put that just full-on disclaimer, are there certain topics that can't be discussed, like political conversation, or not that they would discuss anything confidential, but is there something that, when they're putting that disclaimer, that they should stay away from regardless, or does that just keep them free and clear when they use that?
I think generally speaking, it keeps you free and clear with the limitations that we talked about before, the confidentiality, the inaccurate piece, discussing our staff members, that would be problematic. One case that comes to mind where I think it was from a district in Ocean County, I will not name it, where a board member had the disclaimer but said all kinds of horrible, disparaging, racist comments. And they found that even though you had that disclaimer, you're still a public official. And for you to go out and publicly malign a particular segment of the community really undermines the trust that the community needs to have in you as a board member. And I know that's not what you're talking about, so that would be another limitation, though. But generally, the courts and the commission do recognize that board members have pretty wide latitude with the First Amendment, with certain limitations.
Thank you.
Sure.
My second question is regarding the PTO. And so I understand that they can't give direct orders to staff in that situation, but are there any other instances, example, if they're handling money or fundraising or things like that, that the board member should abstain from or steer clear from?
Look, I would probably suggest if you were a PTO officer, and the PTO was making a nice donation to the school district, I would advise you abstain from voting on accepting that type of donation. But handling money, I don't think would be a problem. Again, it really has to do with what type of interaction you're going to have with the staff. So if you're a PTO president and you go into the classroom and you start telling the teacher how to do their job and how to run this particular event, you're starting to cross a little bit of a line. That's not to say you can't have interaction with staff. You can. Of course, a PTA is going to have interaction with staff. It's the fact that you don't want these staff members to feel that you're giving them an order, not in your capacity as the PTO president, but, oh, this is Val, the board member who has the ability to vote on my contract renewals, and now I'm concerned that if I get on somebody's wrong side, it's gonna affect my employment. So that's what you have to kind of put your shoes in the person on the other end of it, and is your conduct going to somehow create some sort of, I'll call it, fear or concern on that person's part that their employment could be impacted.
Thank you. Thank you
Sure.
so much.
Anything else? Any other questions?
Mark, I had two things I needed clarified, if you could. In the Code of Ethics E, that you can't take any private action that may compromise the board.
Yep.
Would that entail, let's say, a board member taking a meeting with a community member to discuss a concern of theirs in private? Would that fall under Code of Ethics E?
Yes, it would. As a matter of fact, I have a case in one of my districts where some board members, out of the goodness of their hearts, seriously, decided to meet with some community members who had a concern. These community members had come to our meetings pretty regularly and were pretty vocal. And the board member said, you know something, we're going to sit down, we're going to go meet at the diner and listen to them and have a conversation. It was not authorized by the rest of the board. It was done unbeknownst to the rest of the board. Well, the community member, this went into the no good deed goes unpunished category. The community members recorded the conversation and then used what they said against them and then filed an ethics complaint to make matters worse. And the School Ethics Commission said that it was really private action. They were talking about board matters that wasn't authorized by the board. So I think board members have to be careful about having private meetings. There's ethics cases where board members have gone off on their own and met with the union officials, again, without the knowledge of the administration, the rest of the board. So those meetings can be somewhat of a slippery slope. You have to be careful.
Thank you for that. And my last question was in regard to the indemnification. When there are ethics charges against board members, the district obviously incurs the cost, but how costly is that every time there's an ethics complaint that is issued against a board member, or if there's several complaints issued against several members, how does that add up for the district and for the taxpayers?
Yeah, a lot of it is going to be governed by the board's insurance policy. Some of my districts have no insurance, so I've seen some of these cases in the past have cost boards $50,000 to $100,000 where they don't have insurance. In a district like Marlboro, we have a deductible. I think it's about $10,000 per case. So every case that's filed, and the fees are going to hit $10,000. They just are, because typically there's a hearing if the case is not dismissed right out of the gate, and that even the dismissal requires a legal brief by the attorney as to why it should be dismissed. So each of those cases, probably in a district like Marlboro, will cost $10,000 per case. And by the way, I should have said this at the beginning. To me, filing an ethics charge should kind of be the last resort measure. I have board members that often come to me and they want to file ethics charges against other board members or administrators or vice versa. To me, I always like to try to resolve things with a cup of coffee if we can, and let's see if we can figure it out and that sort of thing. Going to the ethics commission should always be, in my view, a last resort measure. These cases oftentimes take years, literally years, to see them through from the beginning to the end. Sometimes the board members are not even on the board anymore by the time the case gets heard. And I'm not saying that there are certain cases that should go to the Ethics Commission. Certain cases are important, involving serious conflicts of interest that need to be adjudicated. But for some of these more petty differences, to me, I think it's best to try to work them out internally. You know, one of the cases I talked about is a board governance issue. That to me means maybe having a conversation with the superintendent, board attorney, the board member who maybe is going off the path, and saying, hey, look, you're off the path. Here's what you need to do to get back on the path, and try a remedial approach first would be my suggestion.
Mark, another question that I was reading in one of the examples, it said that if the complainant is found that the charges were frivolous, there could actually be something against the person that filed the complaint. Yeah. Can you tell me more about that one?
Yeah, so in the example that I talked about before, the case with the pride mask, where somebody said it was a violation for you to wear a pride mask at a board meeting, the commission said that that was just silly. Like, wearing a mask that says pride is not a violation of the ethics, and they actually found that complaint to be frivolous. And I'll have to check the code, but they can issue a fine, and they probably did issue a fine. It's not a huge amount. Again, don't quote me on this. I think it's somewhere in the neighborhood of probably like $100 to $500. I forget exactly.
I thought I read it was like $300 to $500.
500. Okay, there you go. So they can issue a fine. Doesn't happen often, but they can do it for cases that they find are not grounded in any fact or law whatsoever, basically.
Is just to follow up on that, I'm sorry.
Oh, yeah.
Is that when, because some of these cases were board member as a complainant versus board member as a respondent, so is that fine if it's a board member as a complainant, or just it could be a community member, anybody?
Community member, anybody. It's not just, the frivolous piece is not just bound board member to board member or administrator to administrator. Anybody could be found to have filed a frivolous complaint. And I always like to, when I represent board members in these cases, to request that the commission find that they are frivolous, if I can.
Thank you, Mark.
Sure. Just one final point. Kerry, I probably should have had a slide on this. You remember the NJA, and you asked a question before. So the ethics rules prohibit you from having any votes on or participating in negotiations with any of the NJA units. But what it says is once we have a memorandum of agreement with salary guides, you're allowed to fully participate and ultimately vote on the contract. So if you have questions that come up along the way, just give me a shout.
I definitely will.
Okay. Any other questions?
Actually, I just have one more. Yeah. Because as board members, we live in our own community, obviously. So, just to piggyback off of what was said about meeting with people privately and they tape recorded and all that, what happens in the situations where you are in your everyday life at ShopRite, you run into a friend, you start talking, maybe you're talking about your child's teacher.
You do their hair.
What? Oh, you're frustrated. You're like, whatever the case is, somebody overhears you. Yeah. Obviously, you're not making a disclaimer talking to your friend at ShopRite, right. But if somebody overhears you, can they say, well, I know that she's a board member and she was complaining about something and that's unethical? Like, does that ever find its way to an opinion?
Yeah, look, you were elected by the people. You have a right to talk to the people about Marlboro board issues, as long as you're not discussing things we talk about in closed session, as long as you're providing accurate information, and as long as you make it clear that this is like my own opinion, just so you know I'm not speaking on behalf of everybody else, even though there may be other people that feel the same way I do. Just be careful, because nowadays everybody's recording everything these days, I see, so you have to be super careful about that, and just be wise about what you speak about. If somebody overhears it, it shouldn't be an issue if you're talking about something that's a matter of public record anyway, which is, as a board member, what you should be talking about, things that are public anyway. You shouldn't really be talking about, say we're thinking about adopting a policy on X and it's still in the deliberative phase. even though that's not technically confidential, I would tell a board member, you really shouldn't discuss with the community something we're thinking about doing until we're ready to completely roll it out, for instance.
Well, I was specifically talking about, you're talking, in my case, I'm talking as a mom in regards to my kid's education, talking to another parent about their kid's education, and someone overhears it and was like, they're complaining about a teacher in the district, or they're complaining about a class party that went, whatever the case is.
Understood.
You know what I'm saying?
Yeah, so you're, in the example you gave, you're not talking about anything having to do with
the board.
You're wearing the parent hat.
The parent hat, which I'm not making a disclaimer to a friend, but then somebody overhears you talking.
I would just be careful in the sense that because board members have to support and protect school personnel, I wouldn't want you in that example to say something negative about a teacher that some other person overhears, and now they're going to say, oh, Kerry was not supporting school personnel. You would say, well, I was not talking in my capacity as a board member, but the fact is you're always a board member.
You're always on guard.
And on guard, should be
Yes.
on guard too. So I would be, careful about negative comments about staff made to community members, even if you're doing it in your capacity as a parent, I understand the pickle that you're in there, though, yeah. Anything else?
Not that I complain, I'm just throwing it
I know,
out there.
you're
I'm
good.
just saying.
You're good.
Okay, thank you.
All right, thank you. You
Disclaimer.
know where to find me if there's any other questions.
Thank you very much.
Okay, sure. Thanks. Thank you.
Okay. Old business? Carrie?
I do have some old business. I know there's no liaison reports tonight, but I did receive an email from Mr. Messinger, who is the Marlboro representative of the Freehold Regional High School District. So he sent me a very comprehensive email about the budget meeting that they had this past Thursday. So I did not want to wait until our next board meeting to share some information. Mr. Amster touched on it a little bit, but I'm just going to go into a little bit more detail. Like I said, it was comprehensive, so. On this past Thursday meeting, they approved the 2023-2024 budget to spend $209.2 million. The state reduced state aid from $50 million to $25 million. State aid supporting the budget has dropped from 26% to 12%. Mr. Messinger said they literally, in his words, cut to the bone. We educate our kids for $14,207 per student. The New Jersey average for a high school-only district is $19,000. Marlboro residents will pay a tax rate in the coming year of $0.486 per $100 of assessed value. If you need me to repeat anything, just let me know. So they had to make cuts. They reduced 19 positions, 19. They cut the building allocations to principals. They eliminated their courtesy busing, saving the district $3.7 million by doing that. So what does that mean when you say you cut courtesy busing? It means that if you live within 2.5 miles of the school, you are now a walker. You're walking to school. This also means that for students who are eligible to catch a bus but live in developments or complexes, they might have to walk further to their bus stop. This will affect 30% of the student body. In other notes, the roofing work at Marlboro High School is complete. In the summer, they will begin paving work in the parking lot. Their summer school, or ESY, was moved to Marlboro when it's usually at Colts Neck due to Colts Neck's roof being replaced. And since they did not utilize their allotted snow days, they are going to have an extended Memorial Day break, having the Friday off and Tuesday off. So good for them. That's it.
We're just going to backtrack we'll go back to old business if anybody has, but I have to do policy development and community relation matters. Val, please.
Policy development and community relations matters. Superintendent of Schools submits the following resolution for approval. 1, Code of Ethics. I so move.
Do I have a second? Jessica? Any discussion? I see none. Vin?
Sure. Mrs. Rosado?
Yes.
Mrs. Seward?
Yes.
Mrs. Jankowski?
Yes.
Mr. Olonsky?
Yes.
Mr. Petruno?
Yes.
Mrs. Piernick?
Yes.
Mrs. Mendez?
Yes.
And Mrs. Amster?
Yes. Any other old business? Thank you, Kerry, for your
I don't know if this falls under old or new. I just have an update from the Communications Committee. Okay, so since this is our last meeting before the scheduled coffee talk, I just wanted to remind parents of the district that the social media platforms, the Facebook and Instagram accounts, now have a Linktree link. Thank you to the team in the communications department for making that happen. The coffee talk is scheduled for May 10th, which is Wednesday night from 6 to 8 p.m. in the board building, pending the RSVP so that we have capacity for the meeting. An invitation was sent out to all the board members, and the respondents were first come, first served. So myself, Kerry, Val, and Kathleen will be in attendance. It'll also be an opportunity to meet Michael as the official new acting super. Congratulations, since another contract has completed. Now it's official. Congratulations. Also, I just wanted to remind everyone, there was just some chatter on social media that there was a conflict that same night. I am aware of the 5th grade band, 7th grade bands. I'm sorry, I can't remember off the top of my head. 7th grade band's presentation performance is also that night. It's literally impossible to avoid any conflicts for the scheduling of this coffee talk. So please know that it was not intentional. And coming from a home of 3 children, conflict is very normal. So just know that that wasn't done deliberately. And that's all I have to say.
Just make sure to return the acknowledgement letters signed to me, and then I'll take them back to the board office. Thank you.
Any other board members with old business? Okay. New business? Okay. Public comments, Vin?
I have none on my list, but would anybody like to speak? Mr. DiMaria?
Apologize for the phone before too. That was me. Sorry about that. I want to thank the board members and some of the parents that stayed later at that marathon meeting last week that spoke to me. It was really nice of you guys. And still, it's not lost on me the amount of responsibility and pressure that's placed on people that volunteer to come in and make really hard decisions. It's not lost on me. And thank you for that report. That's sobering from Freehold. That's sobering. Kind of puts everything in its place. Getting up and speaking, just listening to the budget and the reasons for it and everything, and just kind of coming up off the cuff. I was really worried I didn't come across clear enough, and apparently it was okay. I just would like to just reiterate the statement that even though the positions go away, the responsibilities don't. They got to fall on somebody. It's got to fall somewhere. I remember years ago we were thinking of getting rid of all the kindergarten assistants at one point. Cooler heads prevailed. They went to half, right? But still, when you get that half, where is that 50% of responsibility going? It's kind of like the same thing. But at that board meeting long ago, they said the same thing. We looked under every rock. We shook every tree. I remember the words. Ironically enough, after the meeting, I walked up to somebody and I said, I could save the district $500,000. And they looked at me like, what are you talking about? Some art teacher over in some elementary school could save the district $500,000? And they said, well, give it to me. And it was nice because they took me seriously. And I gave it. And this person's like, that's amazing. Sadly, we're not going to do that now. We're going to do that next year. And I heard that, and I'm like, oh, wow. So it wasn't about looking under every rock and shaking every tree. It's more about priorities. Now, I'm not saying that about you guys. That's a whole different board. I know the song and dance. But from my past experience, it was tough to swallow. So please be very, like I said before, please very delicate with the teachers. And you guys are doing policy, so you don't have, we just heard about that. You can't do anything with the teachers. I get it. It's kind of going in that direction. Congratulations, by the way. The personality trait of a teacher that goes beyond, the one that strikes me the most is agreeableness. So even though you kind of ask somebody to do something, they don't see it as a question. They see it as do it. And you want to do it for the kids. I'm hoping we don't manipulate that idea to make people do more with those responsibilities that are floating in a vacuum. And now they're doing that stuff kind of for free. Just got to kind of watch out for that. And with the last 17 seconds, then please give me some rope here. At the board meeting, there was a pie chart, and had the population of Defino as being 7% of the total population of the district, which meant that that's the lowest population in the district, but I see 540 kids a week. So I was just wondering, and thank you, how that actually comes to fruition in a budget and how monies are allocated when you're saying, well, this school has only like 390 to 410 kids when they actually have 540. So how does that work within the budget? It's just, I'm a layman, I don't understand. There's probably good reasons behind it, and I was just wondering, because it was presented in public at a board meeting, if you can possibly get back to me whenever to try to understand, you know, what that means on the ground level. You know, because we had to cut general funds. So I was just kind of like wondering how that works. All right, that's it, thank you.
So I believe what he's referring to is the enrollment. So Dr. Blair, you can jump in if you want, but there are some sections that are special ed related that are housed at Defino, and they're included in their enrollment. Unfortunately, the principal doesn't get the allotment for that specific enrollment that's budgeted by Dr. Blair in special education. So I believe that's what you're referring to when it comes to the 7% population, but you see 540 kids. Not all of them are general ed related. Some of them are special ed related, or they have IEPs, or they're in certain classrooms where they're self-contained, where they're budgeted by Dr. Blair for those things for that classroom.
Yeah, of course.
I'll tell you something. You guys make me feel really comfortable here, so I could come back. This is what I have a friend. I brought a parent friend. This is good times. You can come see it. Even with that population, like just doing the math in my head, it kind of doesn't overcome that gap between, well, you know, as it stands, it was looking at the least populated school in the district, and there's other schools that might have like, I think one other school had like maybe under 200 kids. So it's like, how did that happen? Where and I don't want to say the number out loud because I don't want to like predict, but I don't think that number actually overcomes the percentage, in a sense. Because I believe that Defino might be, don't hold me to it, might be like the second largest elementary school in the district. But I'm not quite sure, can't hold me to it. So I was just wondering if there was anything else in addition to that that's bringing that number so low down. You know, because I'm thinking it in terms as a person who gets allocated a certain amount of funds every year, you know, per pupil that's coming from my administration. But that amount, as equitable as trying to be made, that's coming from somewhere else. So those decisions are made based on whatever monies they're getting and then dispersing it out equitably. So I'm just kind of trying to understand, you know, am I getting my bang for the buck? If
I
I'm
believe you
looking
are.
at the 7%, you know what I'm saying? You know, kind of like that. But I'll come back.
Thank you, Mrs. DiMaria.
I learned, that's loud. I learned through me questioning you with like Abbott and all that stuff that kindergarten goes under Abbott and Mr. Preno's in charge of like all of kindergarten. So
Correct.
would that affect Defino's, I don't know how many sections of
Correct. So
kindergarten
so
at Defino, would that make a difference?
Correct. So that affects it as well. You have the special ed related piece in which Dr. Blair budgets for those students, and then kindergarten, that budget falls solely under Abbott. So they budget for all of the kindergarten students. So thank you. That goes into some of your question as well of why it's so low. Because I believe when I did that presentation, both middle schools and Dugan comprised the 50%. And when you calculate that real quick, it's almost like 2,300 kids between those three schools. Unfortunately, Defino, you don't, for when you budget for Defino, like when I speak with all of the principals and we allocate based on their enrollment, Dr. Stradek does not get the budget for the kindergarten students and the special ed students. They have to go to the appropriate departments or the other school in which those funds are allocated for.
Any other questions?
Ashley McCormick, 16 Riley Road. This is off the cuff. So I just wanted to clarify. Mr. Ballone, I received an email from you. Thank you so much for responding right away. I just wanted to put it on public record. Correct me if I'm wrong, but with the budget cuts, No MTEA teachers were laid off, including non-tenured teachers, or not including non-tenured teachers? That's the first question. The second thing is, there's a lot of chatter online on social media, and I cannot stand when it's misleading or not factual. I just want to clarify that Mrs. Rosado brought an idea to Mr. Ballone regarding the health curriculum webinar. Mr. Ballone, you then took it upon yourself, as this is your right, of course, this is your job, to put it into play for the 23-24 school year. But that is not a votable action, so no one on the board will vote for that to be placed, right, to be done. Almost like the integrated program. You guys changed the integrated program, but it wasn't a votable action. The district just did it. And that's it. Thank you so much.
Thank you, Mrs. McCormick. So your first question is a little more complicated. It's not a simple answer, right? The positions that were eliminated, be it the coach positions, which fall under the MTEA, those positions, all of those individuals will be going back into a classroom. That is not to say we didn't make cuts elsewhere. We make cuts for non-renewals, right? So we do have those as well. So I just want to be very clear. There are non-renewals that take place every year, but the coach cut is not part of that. Those are typically done, well, in some cases they're done for performance, right? In other cases they could be done as reduction in force. We didn't have any of those this year, but those are some ways that other positions could be cut. So I just want to be very clear. We make cuts every year, but they're not necessarily budgetary cuts. And some of those cuts that we make they get filled again because those are positions that are in the budget. But the 6 positions that we're talking about, math and literacy coaches at both middle schools and the 2 technology coaches at the elementary level, all of those individuals will be going back into a classroom. And on top of that, any non-tenured teacher who we intended on keeping will be here as well, due to retirements, resignations, so on and so forth. So I hope that clarifies your first point. The second point, with respect to the health webinar, just for clarity, it's going to be for this year. Okay, so the health webinar, in conjunction with the communications committee, we've aligned the date, and we are 99.9% sure we will go out with a communication very shortly that it will, the webinar will be held on Monday, May 22nd, and that actually allows some time to have a coffee chat, talk to the community, give them an idea of what it might look like, also allow them to be introduced to me in a less formal way. And then we will proceed on May 22nd. That's again, the 99.9% plan to deliver 2 webinars.
There's also another board meeting in between.
Correct.
May 16th.
So we have many opportunities to clarify.
Have conversation.
And I just want to bring to the attention of the community, a year ago, actually more than a year ago, 13 months ago, the New Jersey Department of Education came out with a clarifying broadcast. And if you're not sure what the broadcasts are, this is how the New Jersey Department of Education communicates with the 600 plus school districts in New Jersey. And the title of it is Clarification Regarding the 2020 New Jersey Student Learning Standards, Comprehensive Health and Physical Education. And this was a broadcast that came out. They felt compelled to go out to the 600 plus school districts because the comprehensive health standards were a topic of conversation last year, and really when they were first coming out, but they really came to a head last year, as you all know. And I'm just going to read a few excerpts from that broadcast. The full broadcast is dated April 14th, 2022. They are all online. You can Google them. So you can read the full broadcast if you'd like, but I'll just pull a few excerpts from there. There's one section called LEA discretion to adopt curricula. LEA is a local education agency, which is us, right? Marlboro Township Public Schools would be considered an LEA. The NJDOE does not review, approve, or actively endorse instructional materials such as sample lesson plans, textbooks, software, or videos in any content area. They go on to say, generally speaking, the state does not mandate curriculum. They go further to say, essentially, I'll paraphrase, that they do not approve what it looks like in our classrooms. We get to make those decisions as a local LEA or school district. So I know there were some conversations. I did have some emails and conversations with parents. I know I have some upcoming ones as well. And I'll help explain that, because I think some members of the public do believe that we didn't receive permission from either the NJDOE or the Monmouth County Superintendent's Office. Notwithstanding, I actually did have conversations with Dr. Richens about this. And so we do have discretion, and it's very clearly stated in that April 14th memo from last year.
Mr. Ballone, I just want to also add on, because we've had so many conversations about this in regards to the delivery of this in a webinar. There is a licensed health teacher, not just a random individual giving this. There's going to be a lesson plan structured the way that any teacher would administer instruction in a classroom, with an active engagement, a model mini lesson. All of the components of a lesson will be there. It's not taking the place of teaching. We're not reverting back to virtual learning. It's a 30-minute period, very similar to any of the back to school nights or parent teacher or anything you've had. Marlboro has had other informational sessions online throughout the year, correct?
That's correct.
So I just wanted to clarify that as well, because I know there's been a lot of chatter about that.
Yes, this week I met for 2 hours with the teacher who will be delivering that lesson, and also with the supervisor of PE and health. We sat in this building the other morning. My days are
Blurred.
kind of combining, so I don't know the exact day. It must have been, was it even yesterday? Probably was yesterday. So it was yesterday morning. We sat from 9 to 11 and essentially planned the lesson out. Me being a former educator, I lead the district in the teacher evaluation for all certificated staff. So I found it important for me to be there, the supervisor to be there, and then the teacher delivering the content. So we basically sketched out the framework. She's going to flesh it out a little further, and it will have all components of an effective lesson, and it will be obviously delivered by a certificated staff member. And the only other thing that I think is worth mentioning in that broadcast at the very end, it's interesting that the DOE talks about family and community engagement. And if our overarching goal, which I know this board's overarching goal is to include family and community in engaging, they go on to say the strongest curriculum is one reflecting the input and expertise of the entire school community. And this webinar is going to do just that. It's going to welcome our families to sit alongside children with content that I think we all can agree, regardless of the side that you sit on, whether you think we should do this or not, that including families, especially with this sensitive topic and standards that are being put forth here, that I believe is the best way to go here. And I said it last meeting, and I'll say it again, I was not forced to do this. The second Mrs. Rosado brought that idea to the table at the curriculum committee meeting, I remember saying, quote, I love it. And that's how we'll do it.
Thank you.
Thank you, Mr. Ballone.
Thank you.
Aldo.
Based on the conversation and the comments that we had heard at the last meeting, I had also afterwards, thinking about the comments that were brought to the meeting during the public comment section. I think, as I was thinking about them, I think that there may have been some misunderstanding about what exactly the webinar, was going to involve and what it was. I think that the misconception was that the curriculum was changed somehow, but the lesson, if I'm not mistaken, and tell me if I am, the lesson is still the same that was voted on and approved at the curriculum meeting. It's just the delivery method of the lesson, so rather than being in a traditional classroom setting, it's on a webinar, but it's still the same lesson that would have been. So that didn't change, just like other townships, had opted for like a take-home lesson with a packet that the students brought home. We're just changing the delivery method of the curriculum. And that was my one observation from the last meeting that I just wanted to clarify. And then the other question I had was, it sounded like, I don't recall the community member's name, but it sounded like their concern was, if a parent didn't feel comfortable sitting in the webinar with their child, if their child wouldn't feel comfortable to ask a question with the parent sitting beside them, is it mandatory for the parent to attend it with the child, or can the child just log in and take the, can the parent say, go ahead, it's time for your webinar, just go ahead and, I don't need to be there, you're okay to take it?
So the first portion of your question, yeah, no change to the curriculum. We're just essentially providing the lesson in webinar format. So that's the first part. The second part is parents are not required to sit alongside children. We're just offering that ability to do so. And the other piece is we are also providing an environment where students they might not ask questions in the moment at the webinar, they might not ask questions to their parents in the moment. Every health teacher is going to have a mechanism where children, just like any other subject or school day, can ask questions to them on the side, right? If they have a very specific question that maybe they don't want to raise to the whole class, our health teachers will have a way for students to do that and to support them.
Okay, thank you. That's what I thought. I just wanted to confirm, and I appreciate the answer, and I appreciate Christina and the curriculum committee, because I think that that's a fantastic idea. I really do. So, thank you.
I was trying to save this next piece for the coffee talk, but I guess I'll talk about it now. I just wanted to reiterate that outside of my capacity as a board member, obviously I'm a parent first, and I am part of the X percentile of parents who did not opt their child out of the health curriculum. Although I don't feel it necessary to directly share this information and be vulnerable in this way, I just wanted to be known that as part of the curriculum committee, I was also taking into consideration, as a parent who has a child in 8th grade that is participating in this webinar, how I would expect this to be taught, or how I would hope that my child would be educated on this subject. So I am not an opt-out parent. I don't know why there's this narrative traveling on Facebook that I am part of a minority group that didn't want this taught to my child. I just wanted to clarify that I think communication between the districts and the parents is vital to debunk any misinformation that is floating around. So my daughter might kill me for sharing that, but I just want it to be known that I'm a parent who has a child watching this webinar as well.
Any other comments by the board? Any more?
Anybody else like to speak?
Sorry, Kathleen. Seth Amser. So I'd just like to say one thing. I've been coming to meetings quasi-ly since about 2018 when Kathleen became interested in running. And I just have to say, I know some of you have run maybe for this reason as well, is that there was a perception that the board didn't listen. They cut people off. There wasn't a discussion. This back and forth. Kathleen thinks I'm crazy, but I spent, a number of hours going back and looking at old board meetings. And I just like to say, shout out to Michael. When he was a president, meetings were run very similarly to this. People came up, they had a chance to speak their mind. There was back and forth discussions and a thorough hearing of, the people's concerns and debate. I never understood why, I think last week was a perfect example. You were here for 4.5, 5 hours. It took a lot of time and effort to do that, but I think it was well worth it. So I commend you for doing that, and that's really all I want to say. Thank you.
Thank you, Mr. Amster. Anyone else, Ben?
Seeing none?
Okay. Executive session resolution. Be it resolved that in accordance with the provisions of the Open Public Meetings Act, the Marlboro Township Board of Education shall conduct a closed executive session pursuant to the personnel and legal exceptions prescribed by NJSA 10-4-12 for the purpose of discussing matters of attorney-client privilege, discussion of chief school administrator search firms, discussion of insurance broker firms, discussion of safety and security. It is anticipated that the length of time of this executive session will be approximately 60 minutes and that action may be taken in public after the executive session. Be it further resolved that the minutes of the executive session will be released when the need for confidentiality in accordance with NJSA 10-4-12 no longer applies. Do I have a second? Christina? All those in favor? Any opposed? I see none. Okay. Good night, everyone. I'd like to call the meeting to order again. Vin, roll call.
Sure. Mrs. Jankowski?
Here.
Mr. Olansky?
Here.
Mrs. Mendez?
Here.
Mr. Petruno?
Here.
Mrs. Piernick?
Here.
Mrs. Rosado?
Here.
Mrs. Seward?
Here.
And Mrs. Amster?
Here.
The board will be asked to consider the following resolution. Resolved that the board approves the appointment of Gillanella Consulting Services to conduct a superintendent search for the district per the terms of his proposal dated April 19th, 2023 at a cost of $10,000 exclusive of advertising fees and miscellaneous costs.
Do I have a second?
Well, somebody,
somebody has to make a motion. Annette, second. Aldo. Discussion, anyone? Roll call then.
Sure. Mrs. Piernick?
Yes.
Mrs. Rosado?
Yes.
Mrs. Jankowski?
Yes.
Mr. Olansky?
Yes.
Mrs. Mendez?
Yes.
Mr. Petruno?
Yes.
Mrs. Seward?
Yes.
And Mrs. Amster?
Yes.
Motion passes.
Okay. Executive session resolution, be it resolved that in accordance with provisions of the Open Public Meetings Act, the Marlboro Township Board of Education shall conduct a closed executive session pursuant to the personnel and legal exceptions prescribed by NJSA 10-4-12 for the purpose of discussing matters of attorney-client privilege, insurance broker firms, safety and security. It is anticipated that the length of time of this executive session will be no more than 60 minutes and that will not be taken in public after the executive session. Be it further resolved that the minutes of this executive session will be released when the need for confidentiality in accordance with NJSA 10-4-12 no longer exists. Do I have a second? Christina? Any discussion? All those in favor?
Aye.
Any opposed? None.